In our news stories today, we will be looking at a young boy who was recently reunited with his relatives. And in our second story, we will look at the situation surrounding a young child who was brain damaged at birth in 2004. The Kingston boy who was found on Tuesday wandering in the Coronation Market has been reunited with his relatives. The child was brought to the Bustamante Hospital for Children by officers from the Darling Street Police Station. Based on information coming in, the child told the police that he was left in the market by his father beside a person named Chin. The Child Protection and Family Services Agency has mentioned that the aunts of the child have come forward and have collected him. The child was extremely happy when he saw them. However, according to the Child Protection and Family Services Agency, they are investigating the circumstances under which the child was left at the Coronation Market in Kingston on Tuesday. In our second story, the information coming in is that the $40 million that was scheduled to be paid out for a young boy will not happen because the judgment has been reversed for this child who was brain damaged in 2004. The Court of Appeal has put a damper on the ruling of the Supreme Court that awarded approximately $40 million to the family of 16-year-old Roe, who sustained brain damage when he was born at the Victoria Jubilee Hospital. The court has labeled some of the conclusions of the Supreme Court Justice Andre Lindo as plain wrong. The child was born at the Victoria Jubilee Hospital in April 2004 to a teenage mother, Miss Howell, and the child was considered to be post-term neonate. This means that his birth was after his due date. He was subsequently determined, having been discharged after 2 weeks in hospital, to have suffered brain damage from bleeding in the brain, which Victoria Jubilee and its parent organization, Southeast Regional Health Authority, attributed to a hereditary condition that would have been unpredictable and untreatable during the mother's pregnancy. In 2009, the mother sued Victoria Jubilee and Sirha. Experts on her behalf argue that the medical interventions that were afforded to the mother and baby in the circumstances of the birth had been inadequate. In 2015, the Supreme Court found that the institution and its doctors and nurses had failed in their duty of care to the patient. This ruling has led to the court having ordered a large payout that would cover the cost of the child's health care. Not 1 cent has been paid over, as the hospital had challenged the ruling on 6 grounds. The family, who is desperate, and Rose's situation has been highlighted before because the Prime Minister donated an undisclosed sum of money to the family in 2018 to help with health care expenses. In a major turn of events, however, the Court of Appeal has found that there was no evidence that the treatment that was administered to the child or his mother by the hospital staff had fallen below the requisite standard of ordinarily skilled professionals, exercising the skills expected of the doctors and midwives who treated him during the labor process. Experts who appeared before the court could not pinpoint exactly when the injuries occurred. They cast doubt on whether the hospital had been culpable of any mistreatment. Not only did the experts not say the injury was likely caused by the acts of omissions of the hospital staff, they were unable to state that the failures they identified contributed to or in any way led to the respondent's injuries. The matter was heard before Justices Dennis Morrison, President of the Court of Appeal, Jennifer Straw, and Carol Edwards, who wrote the unanimous judgment, which led to the payout of $40 million being declined. It could also be stated that the medical staff were negligent in failing to order brain imaging earlier in the face of the respondent's symptoms, which sustained and suggested that there was brain trauma, but there was no evidence that this failure in any way led to or aggravated his brain injury. The Court of Appeal also said that there was no basis on which the Supreme Court found that there was a breach of duty of care in the monitoring of the child's mother prior to or during the delivery. It was clearly a finding made with no evidentiary support, and that it too cannot be allowed to stand. The judgment stated in part, the Court of Appeal has criticized the Supreme Court Justice for concluding that a midwife was unable to recall what had happened at the child's birth. The Supreme Court Justice has said that the midwife's inability to recall spoke volumes to the hospital's negligence. Doctors were also criticized by Justice Edwards of the Supreme Court, who said that she was concerned about the delay in their conducting cranial imaging as part of the investigations into the child's symptoms of a seizure, bulging fontanelles, hydrocephaly, and macrocephaly. It seems to be nonsensical in the circumstances to order cranial imaging at the point of discharge, for if it was necessary when the child appeared healthy when he was being discharged, it must have been even more necessary earlier when he was showing symptoms. Still, the appeal court said that the judge went too far to equate the management and care of the child's symptoms with his treatment to ascribe negligence to the hospital. The attorney at law, who represented the child and his mother, has said that the family was declining to make any statements or comments about the matter. Like, comment, share, and subscribe. This is an extremely sad situation. For a child to have been born in 2004 and to have encountered brain injuries as a result of issues at birth is quite sad. This would mean that grandmother and the parents would have been spending exorbitant amounts of money for the last 16 years to take care of this boy. However, it seems like the issue was mishandled in the courts, and now the Court of Appeal has reversed the decision. It's very heartbreaking to hear that a child was abandoned at the Coronation Market. However, it is very responsible of his aunts to show up to claim him from the Bustamante Children's Hospital. I hope to hear about the findings that the Child Protection Agency will uncover from their investigations. It is even more heartbreaking to hear about the story of the child who was born brain damaged in 2004 to a teenage mother. It seems the Supreme Court may have not done a very good job of assessing the situation that was presented by the hospital and the experts, who thought that the hospital had not done all that was necessary to treat the mother and the child properly before and during delivery. That decision to pay out $40 million by the hospital has been reversed by the Court of Appeal because, based on their assessment and analyses of the situation and the comments and statements coming from the experts who testified at the Supreme Court, there was nothing that they could find to blame the hospital for in relation to the brain damage that the child may have suffered whilst the delivery process was ongoing. We hope that the hospital would have done all that they could to treat this as a high-risk pregnancy. What is your feedback on the matters that have been discussed in our story today? Let me know, do you agree with the Supreme Court, or do you agree with the Court of Appeal on the matters in relation to the child that was brain damaged in 2004? He was born to a teenage mother, and his grandmother decided to sue the hospital, and at that time she managed to get a payout, being ordered by the court in the amount of $40 million to cover his healthcare expenses. But this has been reversed by the Court of Appeal. And also, what are your comments and feelings about the child that was abandoned in the Coronation Market? Thanks for watching. Like, comment, share, and subscribe. Goodbye.